Hi, I'm Berin Szoka of TechFreedom. Thanks for tuning in for episode 4 of TechFreedomTV. Today we're talking about privacy and surveillance with a panel of security and surveillance experts, starting with Nima Guliani, the American Civil Liberties Union, Stuart Baker, who has been called the great Satan of privacy, although remarkably well-informed. Stuart was first Chief Privacy Officer at the Department of Homeland Security and is now a lawyer at Steptoe & Johnson. Harley Geiger with the Center for Democracy and Technology, and Ryan Roddy at the Competitive Enterprise Institute. So let's get started. So USA Freedom Act went down in flames in the Senate recently. Harley, what was USA Freedom and what happened?
So the USA Freedom Act was legislation that was introduced in both the House and the Senate and took well over a year and a half, almost 2 years, to actually get votes in both chambers. And in the House, it was a decent reform of some of the revelations that we now know based on the Snowden disclosures. It would stop mass surveillance by the NSA of our phone records and other communications records. But in the House, it was finally weakened right before the final vote, right before the floor vote, to be unacceptably watered down to the point where we thought that it would continue to perpetuate that bulk collection. And it passed the House, but with the no votes of many of its co-sponsors. Then in the Senate, they introduced a new version. It was much stronger. We supported it. We thought that it did the job, stopped the bulk collection of Americans' communication records by the NSA, increased transparency of the FISA court. But in the end, it failed by 2 votes on a motion to proceed, a procedural motion. It did not get to the floor. There was no debate. There was no chance for amendments. And that is probably the last chance that we have this year of seeing strong NSA reform in Congress.
So we're going to start over again on that in the new Congress. Section 215 is one of the key provisions of the Patriot Act that's driving all this. That expires at the beginning of June.
That's right.
So Congress has to do something. So
maybe it expires. There's actually an interpretation of it, of the transition provision, that could allow it to go for years. There's a transition provision that says essentially, as long as you need it for an existing investigation, it will continue in effect.
But that would just be the investigations, right? That would not be Section 215 itself.
Well,
and that interpretation would likely be contrary to what I think Congress intended. You know, when they wrote the Patriot Act, certainly they couldn't have intended that these broad investigations of just Al-Qaeda, which involved every single American, could continue in perpetuity.
I think there's a reasonable argument that that wasn't what was intended, but the straight language of it, of the transition provision, makes it pretty clear. If you've got an ongoing investigation that depends on this method, then the method continues even after the expiration of the 215 transition period. So if the administration wants to do it, they can continue to seek the use of the process, and it's quite likely that the courts will uphold it. But I'm not sure this administration is going to be willing to put that interpretation forward.
And also, if it expires, they would not, I think you would agree, be able to start collecting new types of metadata from new companies.
That's right. They could keep the current metadata program probably. There's a reasonable argument it could go on for years.
So politically, does this matter? Does it sap the will of Congress to do something before June 5th?
I don't think so. I think that the intelligence agencies view 215 as it is written right now as being valuable in itself. And even though their existing investigations would continue to be able to use bulk collection, if 215 expires, they would view that as a blow to their authority. So I think that there will be a significant push to reauthorize 215, notwithstanding the interpretation that Stuart mentions. And to be clear for your audience, when we're talking about bulk collection under Section 215, we are talking about the NSA working with the FBI to collect the communications records of all Americans. That is their interpretation of the authority. We understand that they are collecting at least phone records, so who calls who, when, how long, but that authority they interpret as giving them the authority to do it for other types of records, including email metadata, location information, and financial records of every American, as if though everyone was relevant to an investigation into Al-Qaeda. And that is, again, contrary to Congress's intent, and we think it raises very serious Fourth Amendment principles.
So before we unpack this, what exactly would the Senate version of USA Freedom have done on 215?
So It's complicated, but essentially what it would have done is it would have still allowed the use of 215 in a variety of circumstances. It can still use it to collect information on multiple people, but the way that they had drafted it was such that you would not be able to get massive scale population information about using the authority. And for collections where you will get a lot of people, they would have retention limits and dissemination limits. So I mean, it's a complicated provision. The reason it's complicated is because they tried to balance both privacy and security. That's hard, and we thought that they did a good job with that version.
Did you want to add to that, Nima?
Yeah, one of the other things that I think the USA Freedom Act did, which was important, was really add some important transparency provisions. I mean, one of the things that came out of the Snowden disclosures was this idea that, you know, the intelligence communities were doing lots of things that frankly not even members of Congress knew about. And so within the USA Freedom Act, there were provisions that would have required, for example, disclosure of the Foreign Intelligence Surveillance Court opinions that were significant. So let's say down the line, we see that USA Freedom Act has been completely misinterpreted and used in a way that nobody intended. You know, we'd have a better chance of knowing that. And it also sort of, I think, starts to peel back some of the secrecy that has existed in this area for so long.
So what's wrong with that, Stuart?
So I think there are sort of three broad principles that the bill did. It did narrow bulk collection to the point where you could only collect within a relatively narrow set of requirements. There are some transparency provisions that I think are problematic. And then there were a set of changes to introduce another lawyer into the process, and I think probably not very well handled in the legislation. The reason I think that the bill didn't pass is it had it was agreed by the privacy groups and by the Intelligence Committee, but not by many of the Republicans, including the Republicans and the Democrats in the Intelligence Committees, who felt that the provisions that introduced new advocates, the transparency, and some aspects of the broader deal on getting rid of 215 were not fully thought through.
So I'm going to disagree slightly with that interpretation of why it failed. It failed by 2 votes in the Senate. 2 people did not vote in favor of the motion to proceed. One of those was Rand Paul, who thought it did not go far enough. And we lobbied, people around this table lobbied pretty closely on that bill. And it appeared as if though it was set to pass until Mitch McConnell began whipping against it. And then it changed. It seems to me that it was a political decision, not a decision made on the substance.
Well, I'd say it's politics. Politics is substance on much of this. And yes, I think McConnell thought that he would get a bill and an opportunity to write a bill and wanted to have it in the first half of 2015 rather than relying on Senator Leahy's values to be incorporated into this law.
And what kind of bill do you think that's going to be?
If I had to guess, I would guess it will start with the USA Freedom Bill and tweak it more likely on things like transparency and whether we need yet another set of lawyers involved in the FISA process.
That's more optimistic than I am.
Nima?
Yeah. I mean, I think that if we're going to sort of do an analysis of why the act failed, we can't ignore the fact that, you know, the day before it was set to go to the floor, there was a lot of misinformation spread about what the act did. You know, you heard a lot of...
This was the op-ed that Hayden put out and McCasey, right?
There were op-eds by Hayden and McCasey. There were statements on the floor by Senate members talking about how somehow the bill would undermine intelligence capabilities. And a lot of those statements either weren't supported by the facts or actually were misinterpreting provisions in the bill. So when we look at the bill, we have the intelligence community on the record saying this preserves our intelligence capabilities. And then when we look at a lot of the programs that are changed by the bill, these sort of mass call record programs that collect everybody's information, when we look at independent analysis of those programs, there's a lot of people who say, look, they're not working. We never identified a terrorist using this Section 215 call record program that collected everybody's records. And so in some sense, I think the political desire to defeat the bill really caused a sense for members that it was in their benefit to raise these national security concerns that weren't really legitimate.
I think it's also, I mean, it's a fact that ISIS has taken over territory in Syria and Iraq, is killing hostages on TV. Everybody recognizes now that we have a problem with a safe haven of people who are going to be able to train and recruit to attack the United States in the United States, just the way the 9/11 attackers did. And these programs, if they are effective, their principal effectiveness is as an insurance policy against that kind of cross-border attack. I think a lot of people got more concerned about that than they used to be, and that's one of the reasons why they wanted to take another look at USA Freedom.
But if that's the way that you view it, then how do you ever scale back any surveillance reform, right? I mean, this is something that, as Nima said very correctly, that there was multiple independent reviewers that said this was not effective. The money quote in the PCLOB report, the Privacy and Civil Liberties Oversight Report on the bulk collection of Section 215 was that it did not make a single concrete contribution to the outcome of any terrorism investigation. And so when you have something like that, and it is so intrusive that it's covering the entire nation, how do we ever scale something like that back if we allow for a domestic mass surveillance program out of fear of a terrorist group that is operating and largely consolidating their power on the other side of the world?
Well, we live in a more dangerous world than we used to, that's for sure, and it would be nice if we didn't have to worry about terrorist attacks of that kind, but unfortunately we do, and every time we are reminded of the risks that we face, there's an inclination to say, well, what would happen if someone launched an attack? What are our protections? How do we address it? And one of the ways in which it is possible to address that risk is to have a backup of this kind of program.
But doesn't that really not address the question of whether having these programs, the balance of the security and the privacy, one, isn't worth it, and two, whether it's taking resources away from other legitimate intelligence capabilities? I mean, when we think about ISIS, we had Section 215. We had, these massive programs, but still, in some senses, even the president admits that we were flat-footed.
Well, they haven't exactly come into the United States and committed mass killings at this stage. The anti-terrorism programs we have to protect the United States have functioned reasonably well up to now.
And to be clear, though, I think that what we are disputing is that bulk collection is needed. That the bulk collection of communication records of Americans is needed to stop ISIS. No one is saying that we should not have any surveillance program, right? I mean, it is the idea is to bring it to targeted surveillance rather than mass surveillance.
And I think it's perfectly reasonable to ask the question, how good are these programs? It would be nice if that evaluation occurred in a fairly thoughtful environment, but it does seem to me that one of the ways that you address concerns about civil liberties is to ask, what can we do to make sure that this information is not misused? There isn't much evidence of misuse of this evidence.
So first of all, if there's evidence of misuse, we're not going to know about it because it's going to be classified. Second, there were very thoughtful evaluations of the report. The President's Review Group, the Privacy and Civil Liberties Oversight Board, and then finally, there was a solution that was on the table that got the support. This is important. The USA Freedom Act got the support of the Attorney General and the Director of National Intelligence, saying that this would not harm essential operational capabilities. And so it wasn't thoughtfully evaluated on the Senate floor. Instead, it was just ISIS is scary, and that worked. And that's unfortunate.
It's worth noting as well that one nuance that may have been lost among many members of Congress is that Section 215 of the Patriot Act does not govern all collection of intelligence by the U.S. government of all people globally. The types of intelligence gathering that's probably most useful to address the threat by ISIS is not bounded by Section 215.
I guess I would disagree with that. The point of the 215 program, it seems to me, the best justification for it, is if someone wants to conduct an attack like 9/11, they will do their planning and their training and their recruiting outside the United States. They will send people here. They will coordinate as little as possible and then launch the attack. And the best way to catch them is that those folks will have to talk to each other to coordinate, and they'll probably have to call back home when something unexpected happens. And that's probably the only warning we will have about that kind of an attack, because they will have planned that attack out well before they send people into the United States. And the 215 program is aimed at precisely that kind of cross-border plot. That's why I think as an insurance policy, it does make sense. I understand the concerns. It's very easy to portray it as spying on all Americans, but in fact, there are a lot of protections against misuse of that data.
So could the collection itself is spying, and if we
well,
are,
no, I think that's where we disagree.
We do disagree. So, but then in the case where we are worried about somebody training or being in the United States and contacting home or contacting associates, the solution that was proposed would not have barred that. If you know one of the suspects, or if you know one of the suspects' associates, you would still be able to get that information under the proposal that is the USA Freedom Act.
The only warning you have is a call to a planner located in the Middle East. That's the only indication that there's something going on that is in the United States that involves terrorism. You're not going to have a suspect until you get that call. And finding that call and then identifying who that person's network is, who their accomplices are, is something that has to be done very quickly if it's a well-planned attack. And that's why it was important to be able to pull all this information together and do those reviews very, very quickly. That's the theory behind it, at least.
So I want to just remind our audience that we're on TechFreedomTV is the hashtag. We'll take questions for the panel today as we're discussing this. Stuart, so it sounds like you're saying on one level that there's a level of political concern about this that just caused members of Congress to want to slow down and go through a better process. It's certainly true that this bill wasn't put through the normal process in the Senate, and that there's, I think, a number of Republicans who probably would have voted for the bill had that process concern not been there.
That's probably right. Look, by the time they voted, it was pretty clear that there was going to be an opportunity to reconsider that under the leadership of Senator Grassley, Senator Burr, rather than under the leadership of Dianne Feinstein and Senator Leahy.
And so I understand that. I also understand the frustration of Senate Republicans with Harry Reid, who really wouldn't let the Senate vote on anything that he didn't want to see voted on. So I get all that. But at the end of the day, let's say we go through the better process in the new Senate under that new leadership. What changes to 215 could you live with? Or what do you think should be the process for deciding how to make the decision about, as Harley says, how to address Americans' concerns about a bulk collection of information?
So I'm on record as saying that I actually think the Senate, and Harley deserves credit for this because he did a lot of the negotiating, the Senate came up with a better solution both for privacy and for effective intelligence gathering when it set the rules for how they're going to narrow the collection. So that particular solution, if we're going to get rid of the program, and I think it does get rid of the program, is better than what the House put together. I think the efforts to make our intelligence programs more public is inconsistent with having good intelligence, and I think that the introduction of somebody who's basically paid to be Al-Qaeda's lawyer in the process is remarkable, since we don't pay to have the mafia represented when search warrants are written.
So you have less of a problem with 215 and more with the other non-bulk collection provisions in the bill.
I think the problem with the 215 reform is that it really does make the program that has been run for the last 10 years impossible to sustain, and it's not clear to me how you will catch people who are engaged in this kind of cross-border attack. But if you're going to get rid of the program, getting rid of it the way the Senate proposed to do it is better than what the House proposed.
I think,
Stuart, I think you said that some of the provisions, I think you're referring to the special advocate provision. One of the provisions in the bill would have created a person in the Foreign Intelligence Surveillance Court who could have argued on behalf of privacy and civil liberties. And you really characterize that as a lawyer for Al-Qaeda. I'm not sure that that's accurate. What we've seen over,
well, he's not representing the government. He's saying the government should do less.
But he's representing me,
well,
right? He's representing someone like me who might have their records collected under one of these mass programs and who has a privacy interest. And what we've seen is that those interests may not have been adequately represented in the past. I mean, you have members of Congress saying, look, the intelligence courts were interpreting the law in a way that I didn't think this could be interpreted. And I think to ignore that problem doesn't really provide a full solution.
I'm not sure it's exactly breaking news or a reason to get rid of judicial process that congressmen disagree with judicial decisions. Most of these decisions and much of the program was briefed to Congress in an unprecedentedly open process compared to what is usually done with intelligence programs. So if people did not know about this program, it's because they chose not to know about it.
Or perhaps they were occupied with other things.
Yeah, that's right. They had other things to do, as happens with everything Congress does.
When we're talking about this extra lawyer, this special advocate, what we're talking about is there's a secret surveillance court in the United States called the FISA court, and that is where the government goes to get applications.
Foreign Intelligence Surveillance Act.
That's right, the Foreign Intelligence Surveillance Act court, or the FISC. And so that is where the government goes to get authorizations to conduct intelligence activities, including many activities that are directed at overseas targets, but also bulk collection under 215, which is domestic surveillance. And the problem that many people have raised with the FISA court is that it is done completely in secret, and the only party whose interests are represented there are the government. So the government works very closely with FISA court judges to craft orders that FISA court judges then approve for surveillance. And one of the fixes, to address this problem where we think that there's been institutional buy-in by the FISA court and they're not hearing enough opinions, would be to have an amicus. So I actually think that the characterization that this is Al-Qaeda's lawyer or even our lawyer is incorrect. It is an amicus. They're not supposed to represent any one person. They're simply there to argue in favor of privacy and civil liberties principles.
So and Nima said this too. Well, you know, he represents me. The fact is we don't know who he's going to represent. He's going to decide what side he wants to represent, what positions he wants to take, and then he'll just argue them in secret. No one will know what arguments he's making. Maybe he's making an argument that will be profoundly inconsistent with our security. There will be a risk that you're creating a group of people who are profoundly hostile to intelligence gathering, who will be briefed on every single program we're carrying out that goes through the FISA court, and who will look for opportunities to cause difficulties for those programs. I find that very risky and institutionally more risky than what you characterized as a one-sided presentation. In fact, the FISA court and its permanent law clerks believe themselves to be a counterweight to make sure that the government meets its requirements and that the other side is carefully considered. The Justice Department has said and often demonstrated that it believes that because it is appearing ex parte, it has special obligations to acknowledge the arguments on the other side. There are inspectors general, there are general counsels, all of whom believe they have special responsibilities to make sure that privacy is appropriately protected.
All of whom failed.
All of whom disagreed with you. But that's going to happen a lot.
Disagreed with many people. They failed to execute a program that seems consistent with the plain statutory language.
No, I don't think that's true.
We will disagree about that. But I will say also
with the committee that passed it, and
the committee that passed it. Which committee is that?
Judiciary and with the Intelligence Committee.
The author of the Patriot Act says that this language was a great surprise to him.
You know, he says, I will not go to this meeting. I actually nominated him for Annals of Disgraceful Privacy Rulings for Privacy Hypocrite of the Year, saying, I refuse to go to these meetings, and I'm shocked that they had meetings and I didn't hear about this interpretation. He didn't go to the meetings because he didn't want to know about these interpretations.
I'd also point out that the special advocate is chosen, is it by the Director of National Intelligence or the AG? I mean, you say that it'll be a group of people that are hostile to intelligence. It's chosen by an intelligence arm of the government.
And it's I think important to note that the court retains the ability to appoint the advocate or not. I mean, so what if what you say is true and really having this person who represents general privacy interests, we don't know what way they're going to come down on some of these issues. If it really does interfere with a judge's ability to make the right decision, he or she has the full authority to decline.
He's not going to conduct a die-in at the FISA court, but he will make arguments that do not fully, there's a very substantial risk that he or she will make arguments that are inconsistent with our long-term national security and intelligence interests because he has no reason to care about those. That's not his job, as he would see it. And he's likely to be chosen because of this remarkable statement that only certain ideologies are to be represented in this office. He's going to be chosen from among people who are already skeptical about our intelligence gathering capability and with almost no ethical requirements imposed on this office at all. He could have other clients. He could be engaged in fundraising on behalf of his 501c3 with Saudi Arabia or Iran and basically saying, I am the person who's standing between you and certain intelligence programs.
It'd be amazing to me if that individual gets a high-level security clearance, if those are his business contacts.
Well, Edward Snowden got a high-level security clearance.
He did not have business contacts with Iran and Saudi Arabia. In addition, so he makes arguments. He makes arguments that are, the special advocate would make arguments that you think are inconsistent with security. And then the government counters it, and the court rules as they will. It's not as if, though, the special advocate has some magic power to make their arguments pass into law.
Yes, he can certainly make arguments, and he can certainly make it more likely that the Court of Review, the Supreme Court, will hear arguments without familiarity with the broad program that results in serious compromise of our ability to carry out intelligence gathering, such as the argument that just the collection of the data without looking at it ought to be treated as a violation of the Fourth Amendment.
So in the end, it sounds like what you're saying is that the only people that should be able to present in front of the FISA court are people who are not skeptical of the intelligence programs, who have familiarity with the programs, and it sounds like you don't want to see these things reviewed before the FISA Court of Review or the Supreme Court.
I am very concerned about having people who are basically paid to dislike intelligence programs in front of the court on a preferential basis.
On a discretionary basis.
Well, but they will all be chosen. They'll be sitting there. They'll be fully briefed into many programs, and they will be looking for opportunities to create structural changes in the intelligence community. I think that is a highly likely possibility. And to say, well, they can have their security clearance taken away, maybe, but that only is if they do something grossly abusive of the process. I think of Ron Wyden, who gave speeches for 2 years saying the American people would be shocked at the interpretation of 215, begging for leaks of the program, and alerting the entire country and all of the reporters that there might be a Pulitzer if they could figure out what he was talking about. He never violated confidentiality. He never actually talked about the program, but there was no doubt he was doing his best to kill that program through somebody else's leaks. You could see the same thing from the representatives of this office going right up to the edge of what's classified, staying on this end, but triggering lots and lots of interest and attempts to spur leaks. None of that is good for intelligence collection.
Ryan, last word on the advocate.
Throughout the U.S. legal system, there are lots and lots of people who are paid to advocate against the government. In some cases, my organization, other organizations here, and we have an adversarial process when presidential binding decisions are being made. We can't have that here. I think you would agree that's even worse than the special advocate to let civil liberties groups come in and get clearance. So to me, the special advocate, subject to some limitations like the ones you mentioned, is sort of a second best way of getting this process to be more adversarial than it currently is.
Okay. A few other issues just to talk about. Data minimization, briefly. Nima, you want to take that one?
Sure. I mean, one of the concerns that's come out of, the USA Freedom Act, and I think generally these programs, has been the concern that, we're ingesting a lot of this data. A lot of it is irrelevant, and what should happen. And so within USA Freedom Act, you saw some provisions that tried to get at this that said, look, we're going to impose, what they called minimization procedures to talk about that would basically put in place procedures as when we had to sort of purge and get rid of data that was determined to be irrelevant.
Stuart, what do you think?
So we live in a world where gathering and storing data gets cheaper every year, and everyone else is saying, well, if it's that cheap to store, that cheap to collect, that cheap to analyze, I'm going to start looking for tools that will go into that data and find important relationships that wouldn't otherwise be obvious. Given that that's where the technology is going, I don't think we should tell the government, you can't go there. So while I'm not opposed to some uses of technology to make sure we've properly protected that data from browsing for the wrong reasons, I'm pretty skeptical of the idea that the United States government should be the only entity in the world that keeps less information once it's collected. That's just not the way the rest of the world works.
So instead of data minimization requirements, you would have internal accountability safeguards?
Yeah, exactly. It's also getting cheaper every year to keep track of who touches that data, for what purpose, on what date, and to even challenge them on why they're doing it, and to look for patterns that could demonstrate misuse. We should be using that. We should have used it more aggressively before Snowden started looking at this data, or data like it, inappropriately, but the same tools that would protect against leakers will protect the privacy of the people whose data we've collected.
Harley?
So I strongly disagree with the notion that data collection doesn't matter and that it is just the use or misuse of data and oversight accountability that matters. Certainly we need oversight and accountability and seeing who's using data for what and protections against misuse, but limitations on collection are essential. Trust is breached at the point of collection, and the internal safeguards, even executive orders, can be swept away with a new administration.
How much trust was breached when we discovered, as we did right at the start, that Google was able to see everything in our email accounts? We've gotten used to the idea that, yes, they collect it all. They serve us ads against it. It seemed a little creepy, but on the whole, since they haven't abused it, we are accommodating ourselves.
It's a very weak argument to compare the broad collection of broad collection programs from a secretive military intelligence agency with a private entity. I mean, I choose to use Google service. I have privacy settings that I'm able to use on Google service. Google actually has pretty good transparency settings. I can see what they have about me. I can always quit, and Google doesn't put me in jail. Right? And
yeah, but Google also doesn't think it's their job to save your life if terrorists are threatening it.
I don't think it's their job to save my life from terrorists either.
Yeah,
but I have no choice.
The government has more important uses to put this information to than Google does. I can live with or without the ads they're serving.
So what you're saying is that you think that they ought to be able to collect it, and this is different for the purpose of security, which is different than saying that it's
the idea that they can collect this.
There's not a breach of trust. There's been a fiery public debate about this for well over a year and a half. I mean, it made a tremendous amount of progress in Congress, and we're going to be debating about it for the next 6 months at least. So I really don't think that it's right to say that the surveillance programs have been, people are just used to it. I really don't think that's true.
Yeah. And the public has been really clear that just the collection is having an impact. So when they've done analysis talking to journalists, Pulitzer Prize-winning journalists, about what it's like to do their job now that all of their sources have a fear that their information is being collected. And that's not just sources who are sharing maybe information they shouldn't be sharing, but people who are sharing information that's not classified.
Well, with respect, no journalist has been targeted through this program. What they're worried about is the fact that they leave tracks in cyberspace of other kinds, which make it easier to find people who are engaged in improper communications of classified information. It's true. It is easier to make those cases against leakers now than it was 10 years ago, because we leave a digital trail everywhere in cyberspace.
But the fact of the matter is the public's lack of trust in the intelligence community and the concern that even if they're not doing something wrong, their information is being collected, is having an effect. And I think to ignore the actual effect it's having isn't really legitimate.
And I want to emphasize something that I said about internal accountability mechanisms. They're important. Unless they're authorized by statute, they can be washed away like a sandcastle on the beach. We saw that happen with searches under 702. in, I think it was October 2012, where the internal guidelines for the DOJ did not allow for backdoor searches, and then they were changed to allow them. So these internal guidelines, they're important, they should be strong, but it is not as if it takes the place of a limitation on collection.
Stewart's defense, I think what Stewart's saying is he would want some of those internal safeguards to be put into statute.
Well,
but they don't replace...
I'm in favor of strong, intelligent restrictions on the access to that data, absolutely, whether they're in statute or in some more flexible form, I'm agnostic on.
Once the information is collected, it's going to get used, and the restrictions around it will ebb and flow once the information is collected. That is why limitations on collection are important.
Ryan, once again, final word on data minimization?
We know when we sign up for Gmail that they're going to scan our email using automated tools to show us ads, or at least they make that clear. We didn't have any clue that the government was collecting all of our, or most of our call detail records until recently. Now that we know, we're seeing people like journalists and many others posting their PGP keys on Twitter. People are going to all these costs because they're not comfortable with the idea that this information is being collected about them. Yes, the government is going to use this information for some good purposes, or at least it could in theory, but it could also use it for lots of bad purposes. There are lots of agencies in Washington that would love to get a hold of this information to punish individuals and companies for doing things that some of us on this table probably think should be allowed.
So, to wrap up on USA Freedom politics, how do you see all this shaking out in the next Congress?
You know, I think that there is a misconception by some that really just pushing forward, a reauthorizing all these provisions that have been used for this bulk collection will be easy. And I just don't think that's going to be the case. I think that you're going to see a lot of Democrats and Republicans be really noisy about the fact that they want some kind of reform. And that's, has the potential, I think, to even divide parts of the Republican Party who see this issue differently. And really keep public pressure up to have some type of reform. But obviously that reform is not going to be easy.
And on the other end of the spectrum, there are people out there, Senator Paul, maybe one of them, there are people on the left who seem to believe that if they just fight hard enough that the programs won't be reauthorized at all. Do you think that that's realistic? And if not, how does the center reauthorize the programs in a way that addresses the legitimate concerns that have been raised?
Well, interestingly, this is actually a tough issue for Republicans because it divides especially the House Republicans. I think Senate Republicans, with the exception of a few people, one of whom was defeated in the latest election. The Senate has been much more centrist on this, and my bet is that there'll be some centrist legislation that comes out in the, probably in May, that is an effort to bridge the gap, to reauthorize, but not to automatically reauthorize the legislation. I don't think the House will be eager to take the lead on this because it is so divisive, actually in both parties. The real question is whether the president will insist, no, I negotiated a deal last term with Democrats, and I'm not going to allow any changes to that. I'd rather see the whole program go down. It'll be a very interesting test of both where the Republican Party is today and really where the president is with respect to working with Republicans.
Ryan?
It's also worth noting that in the 2011 vote which I believe was the last time that 215 was reauthorized, there was a surprising amount of opposition in the House. And this was, of course, before all of these disclosures. Given some of the handful of votes that have occurred on things like USA Freedom, on an amendment by Representatives Massey and Lofgren, one by Representative Amash, it seems unlikely that both chambers can agree to simply reauthorize 215 without any meaningful changes. I see that as fairly unlikely based on what we've seen because of the House primarily, but also perhaps in the Senate. So there has to be, I think, some sort of a deal reached. And over the next few months, the question is going to be, what does that look like? How do we come out in terms of the privacy versus intelligence gathering? And I think it's somewhere in that middle ground is where things will come out, but it'll be complex process.
So, quick predictions. Specifically, what do you think the actual outcome might look like? How would it compare with the Senate bill? Just quickly, predictions down the table.
Scaled down from the Senate bill.
Yeah. What do you think will come out?
I think, there are a lot of options, and it can go in multiple different directions. I'm not sure that I think that it'll probably be focused on bulk collection, maybe with a little bit on transparency. But I think that we'll see a lot of things fall by the wayside. One thing that your viewers and I think that members of Congress should watch out for are provisions that appear to be reforms that are really just masquerading as actual reform. There is a tendency we've seen, particularly in the House GOP, to put forth provisions that really just restate existing law.
So I think that trimming away some of the special advocate stuff is sort of easy because it's not profoundly responding to what has moved the American people. I could imagine a situation in which the bill proposes an alternative to 215 and runs it in parallel to the existing program for a year to make sure it actually works. And then gets rid of the existing program. There are some solutions that address concerns without surrendering the protection we currently have.
Yeah, I think it's a little too early to tell what things are going to look like next year. I think something that could throw a wrench into everything is the fact that these programs are being challenged in court, and we don't yet know where the courts are going to come out. So it's very possible that this debate is altered because of those decisions.
Just briefly, give us a sense of which courts are most likely to throw a wrench in the process, and how.
So right now there have been arguments made in the Second Circuit, the Ninth Circuit, and the DC Circuit. The first of those arguments was in the Second Circuit. And what you saw during that argument was judges ask really hard questions. They were saying, how could it be possible that parts of the statute that required that the government only collect information on relevant materials really mean that you could collect information on everybody in the country? And so we're not sure which decision we'll see first, but it's very possible that any of those decisions could address whether the programs that were run and revealed by Ed Snowden were consistent with the statute. And they could also address, frankly, whether the statute and those programs are consistent with the Constitution.
So my guess is the DC Circuit will uphold the constitutionality of the statute and of the program, and the statute was not challenged there because the plaintiffs were represented by somebody who wasn't a particularly good lawyer. The Second Circuit may well hold that it's a violation of the statute, and the Ninth Circuit is still up. It's a little harder to read. All of that is unlikely to get to the Supreme Court if the program is substantially revised by June of 2015, because the Supreme Court won't have time to take it.
Do you think one of those decisions might come down before June? Or would it come down after?
Second Circuit could come down. Actually, so could the DC Circuit. Both of them could come down before June. I doubt the Ninth Circuit will.
Well, so there's another section at issue in these debates, Section 702. Harley, Nima, do you want to briefly tell us what that's about and what might happen on that this year?
Sure. Section 702, like Section 215, has been one of those sections that have been giving a lot of people heartburn. Section 702 was really designed to target people abroad. And so it allowed the government to do targeted collection where one of the parties was abroad. It was never intended to be a tool of domestic surveillance. But what's come out over the last couple of years is that a lot of what's collected under 702 are the communications of U.S. persons. And once the government collects this bucket of communications, which are some foreign, some involving people within the United States, they can go ahead and search through those communications with looking for information about you or me. And a lot of people, including myself, find that very problematic. It's basically an end around the Fourth Amendment. Under normal circumstances, if you wanted to collect information about you or I, you would go to a court and you would get a warrant for it. And instead, simply because the government sort of, they call it incidentally collected my information when they were looking at a person abroad, they then can keep and retain that information and search through it. This is a part of, this is a section and an authority that wasn't really touched by the USA Freedom Act. There were efforts, at the very least, to close, the searching of that information for U.S. person identifiers, this so-called backdoor search loophole. It wasn't included in the base bill, but we saw during the House Appropriations process an attempt by members to get provisions into their appropriations bill that would have outlawed this type of searching.
So this is a program. You didn't hear anything about how all the independent reviews found this to be an ineffective program, because they all found that it was enormously important to our ability to catch terrorists and gather foreign intelligence. It is enormously important. It required a special statute precisely because while it is targeted at foreigners, it's targeted at communications that touch the United States in some way. Maybe they just pass through the United States, or maybe they're communications to people in the United States. But if they're communicating, if terrorists are communicating with people in the United States, at least half of the communications are Americans because they're in the United States. So everybody knew when they voted for this law that there were going to be lots of communications that involved Americans in this process, and the means to prevent that from becoming a domestic surveillance tool was to say you need to be focused on targeting the foreigner, not the American. You can't use your ability to identify Americans who are calling a terrorist as a way of spying on the American.
Is that enough, Harley?
So a couple of points to remember about Section 702. One, it allows for not just targeting of an individual. You can get information about a large number of individuals. Two, there's very little judicial oversight of sections of these programs, because what happens under the law is that the government goes to the FISA court and they simply certify that this information is needed. There's no court order, there's no warrants, nothing like that. So they do that, they go to the FISA court, they say we certify it, the FISA court is required, if the certification is correct, to give them the order. They take the order, they get information on a large number of people, including Americans, and then they are allowed to look through this information, find if there's information related to a crime, not even the terrorism investigation that supposedly spurred the order in the first place, but any crime, and then they can pass it on to law enforcement. And the agency doing this is a secretive military intelligence agency. That is troubling. And so the reform that has been called for is that when the information has been collected, they should at least get some sort of court order, some sort of judicial process before they search that information for Americans. We think that that is a reasonable restriction.
Ryan, doesn't that seem hard for Republicans to swallow, given their concerns about information being turned over for example, gun registry records? There are all sorts of ways one could imagine those programs going awry from a Republican perspective.
Sure. With this issue and a lot of these privacy issues, there is this strain on the right, organizations like the National Rifle Association, which are always worried that these programs will be used to, among other things, figure out who owns guns. If you're looking,
can I say that's just lunatic. Unless you are engaged in talking about your gun collection with a foreign terrorist that would be a legitimate target of U.S. intelligence, I don't know why anybody would think that the U.S. government would find this a useful way to find guns. If they want to find guns in the United States, they'll just go subpoena the gun dealers' records. This is not hard. It's not hard to imagine how a government that wanted to know where the guns were would find it. And they wouldn't go to programs that weren't designed to deal with that. They'd go talk to people who have those records as a matter of their business records.
Although that's only if they're looking for the people who own guns. If they want to get the communications records of people who own guns, they can do that under 215 because they have it all.
Well, they'd have to change the, they'd have to have approval for that. They'd have to persuade the FISA court that that was a legitimate terrorism inquiry. I don't
know.
think
They just have to say that it was relevant to their investigation, and we're all relevant, so they would have the information.
I'm sorry, I don't buy that. They had to persuade the court that the only way they could run a program that would protect against terrorists, that would allow them to have the information they needed against terrorists, was to gather it first so that it could be searched in the event of an emergency. And they'd have to make exactly that showing with respect to some hypothetical gun investigation. 215 is also, it's an intelligence and terrorism statute. they have subpoena authority that is actually probably broader than 215 today. If you're worried about that, you should be worried about criminal subpoena statutes, not about 215, which is much more heavily restricted than the criminal rules.
Sounds like Stu would make a great special advocate before the FISA court to rein in Section 215. Just to wrap up, anything likely to happen on Section 702? Or is this really not at issue because it's an effective program?
My bet, no.
Section 702 is going to be harder because there's no firm deadline the way that we have with Section 215. There's no sunset.
We're going to do a lightning round here. CALEA, Community Assistance to Law Enforcement Act, has been on the book for many years, requires communications companies, among other things, to build backdoors to their system to turn over information to the government. There's some discussion of having a CALEA 2, of expanding those requirements to apply to tech companies to allow for backdoors for things like email. Is that actually likely to happen anytime soon, or is that pretty much a dead letter in this political environment?
You know, I think that there are going to be people that continue to push for it. I have a hard time believing that we're going to overcome some of, I think, the very legitimate concerns with that. You know, it just frankly doesn't make any sense to me. There's this proposal that we, force developers to somehow build a vulnerability into their product so that the government can peek into their information or get access to their information. What no one's been able to explain to me is how you do that and don't leave that same door open for every other person who might want access to your information.
And Chinese hackers have used such backdoors for Gmail, for example.
No, they haven't. They're really that's sort of a misrepresentation of the situation that has been convenient ideologically for people making this argument. But in fact, CALEA has been on the books since 1994. It's 20 years later. Nobody can actually point to, and in theory, everybody's building these vulnerabilities into their communications that could be misused. No one has pointed to a misuse of those communications. It is true that the Chinese hackers tried to get any classified information they could, including trying to find out who was the subject of existing FISA orders and wiretap orders, but we don't even know whether they got that information.
So it seemed, based on the stories that we had read, it seemed like what was in place was the Internet Services lawful access mechanism.
That's
so,
right.
Right, and it was that the hackers exploited. So it wasn't CALEA, because CALEA is currently relegated to cell phones. What we're talking about is the possibility of a proposal that same backdoor is built into all services. And we're showing, and when we cite this, we're saying that this is an indication of how that lawful access can be misused.
So it's been the law for communications providers, including VoIP internet providers, for 20 years. Show me one example of this theoretical compromise that bad guys are going to be using. I just haven't seen it. And so I think it's reasonable to say, why don't we focus on dealing with abuses that actually have occurred rather than imagining them?
So if we require a mandate to be built into, a government mandate that there's a backdoor vulnerability built into encrypted products, that backdoor vulnerability, even if it is not used by cyber criminals or hackers, it will be exploited by other governments. All right, because it's there. So if we have an iPhone that is being used in Russia, then it'll be used by the Russian government because that is the tool that they will be able to use.
No, that is not necessarily the case. Just as if you take an AT&T phone to Russia, and AT&T is capable of adjusting its switches in the United States to allow a wiretap, that does not mean the Russians get to call AT&T and say, give me a wiretap. This is not necessarily a backdoor. This is access by the company that built the technology. If you don't trust the company that built the technology, you have a broader problem than mandatory CALEA access. That said, it ain't going to happen anytime in the next 2 years.
Quickly, one last thing is that requiring that mandate would also be a huge burden on small businesses that maybe don't build as strong of a mechanism and as secure of a mechanism for backdoor access. But it'd be every startup, every new communications platform would have to build it. I agree, because of these problems, it's dead in the water.
Okay.
And it won't happen. Instead, I think we'll see continued agency threats. The FBI director, the Justice Department will make public and private statements to companies of all sizes, mainly big ones, saying if you don't do this, people will die. So far, that hasn't worked too well, at least publicly. In private, it may have worked, but Turns out if a company has a $500 billion market cap and global market, it's willing to say no, even to the FBI director.
Speaking of agency threats, another issue we've seen come up again and again is data retention mandates. The idea that this is something that some Republicans have gotten behind, to say, well, no, we don't want the government to have this data. We'll just mandate that the private sector keep the data. We had that fight in 2011 over a House bill that was related to child trafficking that would have allowed for, would have required data retention and then allowed law enforcement agencies to access that information with a mere subpoena. So politically, do you think that data retention mandates are going to go anywhere in this Congress?
I don't think so. I mean, again, it's one of those proposals that really doesn't make sense given technology. I mean, every day you open the newspaper and it's data breach at Home Depot, data breach at other private companies. You know, forcing companies to retain larger amounts of information, I mean, you're basically creating a honeypot for hackers. You know, not to mention the extreme costs that it might impose on businesses who now all of a sudden have to build this giant infrastructure to store data that they don't even need.
Stuart?
I don't think what's going to happen here. Data retention has been the favorite policy of the allegedly privacy protective European Union, which has never met a surveillance technique it wasn't more fond of than the United States. And this is part of their program, but it's not likely to be part of ours.
We've been talking about national security agencies. What about law enforcement agencies? So last Congress, ECPA reform, bill to require that law enforcement agencies get a warrant before accessing stored communications like emails, gathered 290 plus co-sponsors in the House, but it stalled in the Senate because the Securities and Exchange Commission insisted that they should be able to have an exception. They should be able to use a mere administrative subpoena to compel email providers to turn over emails from a target. So that tied everything up. This seems like an area where Republicans have a strong interest. They've led on ECPA reform in both chambers, but especially in the House. Are we likely to see something happen, and what would it look like?
I don't think we are going to see something happen. This has been a perennial issue for the privacy lobby and for some tech companies, and it keeps stumbling. And now the question is, who do you hate worse, big banks or the FBI? That's a hard question for everybody. And my guess is that it will continue to face deep resistance from law enforcement and the Justice Department, and isn't likely to pass in this administration.
Ryan?
I agree that the issue with big banks versus the government is tough, but in this big omnibus bill that the House is supposed to vote on tomorrow, one big win for the big banks that Republicans pushed was this tweak to Dodd-Frank involving a complex rule that is beyond my expertise. The point is that it's somewhat interesting that Republicans, and not just the extreme ones, the Ted Cruz's, the principled ones, but also a lot of more mainstream Republicans who have been railing against the regulatory state. The House has passed the REINS Act, which deals with regulation. Many members of the Senate, mainstream senators have been saying we have too many rules and regulations. So with ECPA reform, it's interesting that so far the sticking point, it seems, in the Senate at least, has been that a civil regulatory agency that wants to be able to access information on targets directly through the provider without going through the Justice Department, which has warrant authority for criminal related matters, is what's stopping it. And it's unsurprising that Democrats, who one of their signature bills has been this 1,000-page bill to expand the authority of not just the SEC but the Consumer Financial Protection Bureau, which Republicans despise. It's unsurprising to see them supporting it. If Republicans, however, buy this concern, it will be more interesting. I suppose we'll see what Senator Grassley does.
You can't pass ECPA reform without the votes of a lot of Democrats, and if they get off because of their interest in maintaining regulatory programs, then the bill doesn't pass.
Well, there are a lot of Democrats in the House who supported ECPA reform.
And I'm going to disagree with the characterization that the ECPA reform movement continues to stumble. I mean, just several years ago, it was a very obscure issue, and it has made very steady progress, in my view. In the past Congress, it made the most progress of all. I mean, it passed a Senate committee, and now we are seeing, as you said, more than 260 co-sponsors in the House alone. So that is actually an extraordinary amount of progress.
290 some by my last count.
That's pretty amazing.
Just to wrap up here, I'm going to give you each a chance to share your prediction. Let's do predictions first, and then we'll do off-the-wall things. So predictions politically, what do you think this debate looks like in 6 months? Big picture on surveillance. Ryan?
We'll probably have a bill on 215. ECPA reform will be moving. Whether it has passed or not, we'll see. But with this many co-sponsors, it's hard not to see some action happen in one of the two chambers. At least some serious likelihood of a vote impending. But it's going to take some more work, I think. But it is promising, and I think we'll see something. Whether it's in 6 months or longer, I'm not sure.
Harley?
Initial focus will be on Section 215, and it will be in some ways a rehash of the USA Freedom fight, but with a deadline. And then after that, I think that it's very much up in the air, and perhaps we will see whether small government Republicans really stand by that principle.
So I think the air has been going out of the hostility to government programs in this area really since 3 months after Snowden's first disclosures, as he began to look more and more like just an anti-American crank. And the only remaining live issue is 215. There has to be a vote on it. There will be a vote on it. I predict that rather than the rest being up in the air, I think it's all down on the ground and dead for the rest of the next 2 years.
Nima?
You know, I think we're going to gear up for the fight on 215, and we'll see something on that before June. I suspect that ECPA reform will continue to move forward, not just because people care about it, but because companies care about it. I also think that we're going to see a lot more attention placed on kind of domestic surveillance tools. You know, there's been stories about sort of these stingrays and dirt boxes, which, you know, potentially collect information of large amounts of people's cell phones, including their location. And as these things, I think, become more widely used by local law enforcement, you're going to see some questions asked by members of Congress.
I was going to ask for pet issues. You've already mentioned stingrays. We'll just go down and close with this. Pet issues?
The Supreme Court is going to have to struggle with Smith against Maryland and the notion that when you hand off information to a third party, do you retain the ability to say, but as far as the government's concerned, it's still mine, and you need a search warrant to get access to it? Court and the courts generally have been playing footsie with that idea. Maybe we need to rethink Smith against Maryland. I think that will be the judiciary's Vietnam. They will go in thinking they're going to solve the problem, and they will come out 20 years later beaten by the issue, because it's almost impossible to draw lines there. The only intelligent thing to say is, if you give up your secrets to somebody, you have given up your secrets in a very real way, and that changes your ability to protect them from the government.
That's more or less my pet issue as well, the third-party doctrine and the reasonable expectation of privacy.
And you totally agree with Stuart on everything he just said, right?
No, I don't agree that if you give up your secrets to one party, particularly one that has technical and legal tools in place to maintain confidentiality, that you then give up your secrets to the government and perhaps everybody else. I think that the Fourth Amendment is supposed to protect against unreasonable searches and seizures, and unfortunately this reasonable expectation of privacy is a judicial-created doctrine, allows for very unreasonable searches and seizures that just don't make sense in an age of technology. I am sure that will be solved by the next year.
Amen to that.
Well, since they've covered the third-party doctrine so well, cybersecurity information sharing, now the Republicans have both chambers. We might actually see a bill reach the president's desk if they decide to make it a priority, as they have in two past Congresses. I support legislation that eases some of the burdens on private company-to-company information sharing, but I don't think that legislation should abrogate any common law principles. And depending on how much we hear about cybersecurity in coming months, that may be something that Republicans can do in a perhaps a responsible way. And we'll see if the president threatens to veto it again, which I think he should if it looks like the last bill.
Well, I'll just close with my pet issue, which is Ryan's pet issue. And when he says not abrogating common law principles, what he really means is making sure that users can still sue a company if it breaches its contract with them or its terms of service. If it promises to remove information before it shares that with the government, that shouldn't be prevented by law. And that's something that even CISPA's sponsors said they didn't want to stop, and yet we were concerned the bill would. So anyway, thanks for joining us. 4.5 lawyers. Ryan's soon to graduate law school.
Three 7/8 of one.
Well, there we go. 4 7/8 lawyers have had a great discussion today about surveillance. Thanks to everyone who tuned in today. We'll look forward to seeing you in the new year to talk about more tech policy issues, and encourage you to share this conversation with your friends. So, thanks for joining.